32 guntas.
P7?
P7 pertains to
56.
Survey number 56.
Ah.
56. Even there, KMC Tappa 3 acres, RR number 646. And there's also entry with respect to a mutation, partition, MR number 11 of 7980, which are much prior to the institution of the suit.
Partition is reflected.
Yes.
Yes.
Exhibit P6 is with respect to.
P7L partition is reflected.
Yes, my lord. Partition.
Exhibit P6.
Exhibit P6, 21 acres, 7 guntas pertains to land item number 2, survey number 55.
Ah.
P6, 55. Here also MR numbers are mentioned. MR number 8 of 6869. And the purchaser's name is also entered. Chinnagiriyappa, Nagaratnamma, Kamalamma, Sadashivaya bin Paranna, IHC mutation. 1 of 8384. Govindraju, Paranna. Again another.
And the sale deeds are reflected.
My lord, sale deeds dates are not reflected, but the mutation entries and RR numbers are reflected here.
Yes.
Column number 12.2 does not show the name of the plaintiff or his father anywhere. Now, my lord, if the plaintiff has to succeed, they have to first satisfy regarding prayer B. Only if they are able to demonstrate that all the sale deeds that have been executed in favor of the defendants are colorable, nominal, and fraudulent documents, only then plaintiff will be able to succeed in getting a declaration. Now, these sale deeds, I'll not go back to the facts, but these sale deeds have not at all been produced before the court. No material particulars are given. Unless plaintiffs satisfy with respect to prayer B, they cannot succeed. It is immaterial now whether the defendants have pleaded in their written statement. Now, I am filing an application at 4127 and producing the sale deed dated 7146, and they contending that it is a void document. If they have to contend the document as a void transaction, they could have just spelled out in their written plaint that such and such a sale deed was in fact executed by our guardian. The document is a void document, and we need not seek cancellation of that document, and they could have proceeded. That would have, in fact, would have been a proper exercise. That is not done. Their case is simple. 37, my father purchases. We have not sold. My father has not sold. We are still possession of the property. And 89, they just file a suit. That is their simple case. May I kindly pass over this few judgments? I will not take your lordship to the entire judgment, only the head note.
Yes, sir.
Legal necessity. Another argument was put forth that what was the necessity to sell the entire 52 acres. They went to Malur for good, and retaining a property in Bangalore, that too at Peenya, and going to Malur for good for so many years, that would not have been beneficial to the miners. By the time they would have come back, there would have been no property. So the entire extent was sold to their benefit, and There was an FD that was kept there, and they have utilized that money by purchasing a property at Exhibit P10. That is the first of the judgment. At head note number 3.
Yes.
Mere mentioning and using the word fraud, fraudulent held is not sufficient to satisfy the test of fraud. A pleading / using the word fraud, fraudulent without any material particulars as required in terms of Order 6 Rule 4 CPC would not tantamount to the pleading of fraud. Considering the pleadings and averments in the suit held, the allegations of fraud were made without any particulars and only with a view to get out of the bar of Section 34. This was under the Surface Act. Now, to get out of the aspect of limitation and also possession, that sale deed was not disclosed. All the transactions that has happened intersect between the defendants. At page number 9. (8.1), page number 9.
Yes.
Similar view has been expressed in Charlie Prasad versus Jaiswal, and after considering the decision of the Privy Council at Bharat Dharma Syndicate Limited versus Harsha Chandra, it is held that a litigant who prefers allegation of fraud or other improper conduct must place on record precise and specific details on these charges. Even as per Order 6 Rule 4, in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, particulars shall be stated in the pleading. Similarly, in KC Sharma and Company, it is held that fraud has to be pleaded with necessary particulars. In Ram Singh, it was observed and held by this court that when the suit is barred by any law, the plaintiff cannot be allowed to circumvent that provision by means of clever drafting so as to avoid mention of those circumstances by which the suit is barred by law of limitation. Page number 12. But this is with respect to Section 3 of the Limitation Act. Head note B.
Yes.
Page number 12. Section 3, subclause 1, bar of limitation. Held goes to the root of the matter. If suit, appeal, or application is beyond limitation, court or adjudicating authority has no jurisdiction, power, or authority to entertain the matter and decide it on merits. The court has an independent duty to look into aspect of limitation, even though limitation has not been set up as a defense. Now, with respect to prayer B, Article 58 is applicable. 3 years, as your lordship mentioned. So the first of the sale deed, after the attaining majority, was also executed probably in the year 1960s. And they filed a suit in the year 1989. When prayer number B is barred by limitation, prayer A also does not survive. They can succeed only if they are able to demonstrate that all these documents are fraudulent documents and not otherwise. That's at page number 18, paragraph number 32 and 33. I'll not read that, my lord. Page number 21.
Yes.
Head note number C.
Yes.
Nature of question held affects jurisdiction of court. Section 3 clearly provides that every suit instituted, appeal preferred, and application made after the prescribed period of limitation, subject to the provisions contained in section 4 to 24, shall be dismissed, although limitation has not been set up as a defense. A plea of limitation or plea of res judicata in a plea of law which concerns the jurisdiction of the court which tries the proceeding, since a finding on either plea in favor of the party raising would oust jurisdiction of the court. Page number 47.
47.
47. Head note Amen. Issue of limitation. Duty of trial court to consider if said issue is not raised by parties concerned. Failure of trial court to consider the issue in such case. Effect of right to raise the issue in appeal. Held, it is incumbent upon the trial court to consider the issue of limitation on its own initiative, even if the issue is not raised by the parties concerned. Where the issue of limitation was not raised during the trial by the appellant, state and also the trial court failed to consider that issue on its own initiative, held the said issue to could be raised even in appeal, also on successive appeals. The last of the citation at page number 57. This is now, my lords, the question whether he was a de facto guardian or a de jure guardian cannot be looked into at this stage, because the document 17/1/1946 does not reveal anything as to how he was appointed. It just says that he is a guardian. He could also be a court appointed guardian. Probably it is not just mentioned in the sale deed.
Yes.
So if he has to be nomenclated as a de facto guardian, he should be placed in a witness box, and I should be given an opportunity to examine him. If that has to be done, our 41 Rule 27 application is to be allowed. Without going into that, my lords, just assuming that he is a de facto guardian, I'm not admitting, but even if we assume, this decision of the Madras High Court in the year 1925 on almost similar facts, here also the maternal uncle sells the property of the minor. He was a de facto guardian, as referred to by this judgment. The Honorable Court mentioned that a sale deed by a de facto guardian for necessity is not a void document. May I kindly take your lordships to the relevant paragraph. Page number 63. Sorry, ma'am. At page number 57, the judgment. The first paragraph. The question in this case is whether an alienation by a de facto guardian is valid under Hindu law. The person in question is the maternal uncle of the plaintiff.
Pradeep, where are you reading?
Page number 57, the first paragraph.
You're reading 57.
First, only the first paragraph, Mills, and then I'll take your lordships to page number 60.
Yes.
57. The question in this case is whether an alienation by a de facto guardian is valid under Hindu law. The person in question is the maternal uncle of the plaintiff, and of course is neither the natural nor the legal guardian. The district munsif dismissed the suit, which was the claim for a declaration that the alienation made during the minority of the plaintiff did not bind him. The subordinate judge reversed this decision, holding that the alienation made by the maternal uncle was a void transaction. My lord, at least in this case, the minor has approached the court by producing that document and seeking a proper relief. It has been argued at length for the respondents that the de facto guardian is unrecognized in Hindu law. It may be at once said that if there is such a recognition, I am satisfied that the recognition is more or less modern, and possibly to some extent the recognition, if it is legally recognized at all, has come about by necessity. The earliest case, as far as I know, is well known case in Hanuman Prasad Pandey versus Masumad Babui Munraj Noveri, where the lordships of the Privy Council said, upon the third point, it is to be asserted that under Hindu law, the right of a bona fide encumbrancer who has taken from a de facto manager a charge on lands created honestly a de facto manager, the end, my lords.
Yes.
End of a de facto manager, encumbrancer who has taken from a de facto manager a charge on lands created honestly for the purpose of saving the estate or for the benefit of an estate is not affected by want of union of the de facto with the de jure.
Yes.
Yes. And in the same page, And my knowledge, to the best of my knowledge, this decision has not been overruled. I have checked that, but at the same page, at page number 58, second paragraph. In Mohanud Mondul versus Nafur Mondul, the grandmother purported to sell minor's estate. The court found that she was a de facto guardian, and relying on Hanuman Prasad Pandey versus Musmat and others, it held that not only might a de facto guardian mortgage, but also sell. Justice Banerjee points out that there may be cases where the sale of a part of minor's estate might be more beneficial to him than a mortgage. So even in this case, the sale of entire 52 acres was probably more beneficial than mortgaging it, since they settled at Malur for good.
Yes.
At page number 63, in the first paragraph, from the last 4 lines, first paragraph, last 4 lines, I am clearly of opinion.
Yes.
I am clearly of the opinion that the right of a de facto guardian to deal with the property of Hindu minor has been recognized by our courts ever since the decision of the Privy Council in Hanuman Prasad Pandey versus others, provided that the alienation was for necessity. I may here state that in the present case, the de facto guardian was the maternal uncle who took charge of the minor after his mother's death. And the evidence of DW1 is to the effect that paternal aunt with whom the minor was for a time not in a position to maintain herself. So far as the Hindu society in South India goes, the maternal uncle is treated as the closest relation of a person next to his father and mother. And at all ceremonies and at which presents are given, it is his that it's first handed over. Now this person, Kempu Shetty, was no intermeddler. He has taken these minors to Malur. They were educated there. Exhibits their SSLC certificate and also other character certificate shows that they were in under the care of their maternal uncle. And also later, plaintiff number 1 has in fact married maternal uncle's daughter only, where also their name is mentioned. So they had a complete custody and they took care of the minors for a very long period. And even in the year 2006, their ration card shows that they were residing at Malu. So this is the law on the aspect of de facto guardian. And their judgment at page number 17 of their compilation. What is this? Hindu law always recognized de facto guardians. Page number 17.
Page 17 of their compilation.
Of their compilation. Illa, continuation page. Continuation. In
Yes. ಆ ಮೂರಿದೆ ಅದರಲ್ಲಿ ಯಾವ್ದು ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು? ಬಿಗ ಬಂಚ, ಬಿಗ ಬಂಚ,
ಬಪ್ಪಯ್ಯ ತಳವರ್ತಿ ಬಪ್ಪಯ್ಯ.
At page 17. Ah. Yes.
Following relations are the natural guardians of the person to the property of a minor. The order between the father, mother, paternal relation, then maternal. This to be accepted. Maternal is also natural guardian after their own parents.
Ah. You want to go through? Correct. I think you have cited them. I'll go through. I'll go. What, Pradeep, from remand now you have come to dismissal? Huh? You gradually graduated from remand order to now you feel that this he has to be non-suited. All right, good. Yes, sir. Short reply.
ಸೈನ್ ಮಾಡಿದ್ರು Synopsis. ಇದು Synopsis.
Ah. The Nigle once we are done. One is leave and delay in all the.
I have made a chart in how many years pending in all RFAs so that
Howda.
your lordship can, that is the synopsis which
All right. ಒಂದು ಕೆಲಸ ಮಾಡಿ ಅಲ್ಲ.
ಈಸಿ ಆಗುತ್ತೆ. ಅವ್ರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
Correct. No, you close your arguments
Yes.
and then I'll pass orders
Yes.
on interlocutory application.
No, I am seriously objecting because
Correct.
I will submit my arguments on that also because they say they are not aware, but wakalat and order sheet, whatever we have produced, they show that they are aware of these proceedings from earlier also. They cannot say that now to condone the delay, we are not aware of the proceedings.
Correct. Now I'll note down this, otherwise it will be a confusion.
Yes.
Now, in which all those appeals delays condoned? RFA? This is in time.
In time.
Order. One ನಿಮಿಷ. RFA 912 of 2015. Here also no delay. Next. 342 of? How much is the delay?
20 to 8 years. 8 years.
Close to 8 years.
8 years, close. Yeah, 14 is the judgment, 22 is the appeal.
Close to 8 years.
Yes. Next matter also, 343 of 2020.
One ನಿಮಿಷ. Next. It is same, almost same. Yes. 14. Not yet condoned. Idalli close to 9 years.
Yes, next 23.
Another 9 years.
Yes.
Yes. Incomplete address. So appellant in RFA 14 served through paper publication. Earlier round. Allah, but in first round he was repented by council. Yes. ಈಗ 14 ಅಲ್ಲಿ ಮಾತ್ರ ಡಿಲೇ ಕಂಡು. Yes. Then those connected appeals, there is delay of 10 ವರ್ಷನಾ?
14 to 14, 10 years.
10 to 14 years.
10 years.
ಎಲ್ಲದ್ರಲ್ಲೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ ನೀವು? ಯಾವ್ದು? ಯಾವ್ದು? ನಿಮ್ದು ಯಾವ್ದು RFA? ಅವೆಲ್ಲ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಬರುತ್ತಲ್ಲ?
ಅದ್ರೊಳಗೆ ಅಪೀಲ್ ಮೆಮೊ IA ನಾನ್ ಕಂಪ್ಲೇನ್ಸ್ ಅಲ್ಲಿ ಇದೆ, ಇವತ್ತಿಗೂ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಲಿ ನಮಗ್ ಸರ್ವ್ ಮಾಡೇ ಇಲ್ಲ. We have asked several times, but he has addressed arguments already.
ಏನ್ರಿ you can't be
ನಾವು
so
ಕೇಳಿದೀವಿ.
irresponsible.
Now that is
You
the,
are very irresponsible, I'll tell you. What is this?
after addressing, I did not object for it. He has addressed arguments already.
Now I will delink your appeal. I am not going to decide your
In
appeal.
fact, 2 appeals were dismissed because of this.
I'll not decide your appeal. Very unfair.
Now by way of reply, we are
Unfair
here.
conduct. Very unfair conduct, I'll tell you. Kodri, igle kodri. You lawyers complicate unnecessarily. You people complicate all this. It is the 5th or 6th hearing, sir, and you are yet to serve a copy. What is this? ನೀವು ಇವತ್ತು ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ನಾವು ಕೇಳಿದ್ವಿ, ತಾವು ಹೇಳಿದ್ರಿ ನಿಮಗೆ ಪರಿಚಯ ಇದಾರಲ್ಲ ಕೇಳಿ ಅಂದ್ವಿ. We have asked him.
No, delink, delink. I'll not pass order. No, I can't. I can't. They will make it the ground. What apologies, Sri? Right now you go and you get Xerox.
Please, I shall.
Another same ground is there, but he has to.
Only parties, inserting parties, my lord, that's it.
They are all pendent late transfers.
Okay.
Whatever happens to main appeal.
Main appeal ಅಷ್ಟೇ.
Yes.
ಆಯ್ತಾ?
All those appellants got a cause of action to
Now
file
in
an
those,
appeal.
the transferees appeals batch, there an application is filed seeking leave in all the cases.
Yes, my lord, yes,
Yes.
yes.
And there is a delay application.
Yes, please. And there is no application for any production of any document. Yes.
ಅಲ್ಲಿ ಪ್ರೊಡಕ್ಷನ್ ಏನಿದೆ?
ಇಲ್ಲ.
ಎಸ್ ಸರ್, ನಿಮ್ದೇನು?
Yes, we have given a written submission. It's only
My lord, before they advert to my lord, only judgment I shall cite and I shall close it, my lord. Only judgment, my lord.
ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಸರ್, ಅಟ್ಲೀಸ್ಟ್ This judgment is served on him.
My lord, I shall
First,
serve.
our quadri.
I shall serve it. My lord, wherein your lordship had put a query with regard to the maintainability of the suit with regard to section 31 of specific relief act, my lord. My lord, they have cited a judgment, my lord, wherein it was stated, my lord, the interpreting the provision, my lord, at para 23, it was cited therein, my lord, which the respondent had referred to, my lord. At para 23, it was,
These that paragraphs I'll go through.
Please.
You just let me know what are the paragraphs I'll go through.
please, my lord. In this judgment, my lord, it is clearly,
Citation. Citation, please.
citation 2021 4 SCC 786.
All right, only paragraphs. I will go
Please,
through
my lord,
later.
I shall go. My lord, in this judgment, my lord, the Honorable Supreme Court, Constitutional Bench of Honorable Supreme Court has interpreted the specific relief act, my lord, very clearly, my lord. Your lordship may kindly refer to para 17 of the said judgment,
Para 17.
please. My lord, when it comes to the section 31(1), the important expression used by the legislature is any person against whom a written instrument is void or voidable. An instructive judgment of the full bench of Madras High Court reported in Mupadati Pillai versus Krishnaswamy Pillai involved the determination of section 41 of specific relief act, section 33(1) of the act is the pari-materia provision. This judgment after referring to section 41, then referred to section 39 of specific relief act 1893, which is pari-materia the provisions of section 31 of the act. The court then went on to notice the distinction between section 35, which is pari-materia provision to section 27 of the and section 39 of specific relief act as follows. It may be noticed that the above section applies not merely to the case of an instrument which is voidable, but also one that is void. Section 35 provides for the case of rescission of voidable contract. It is evident that section 39 covers not only a case contemplated under section 35, but also wider field. That is a case of void document, which under the law need not be set aside. In an extremely, the next paragraph, in an extremely important paragraph, then set aside the principle behind section 39(1). When it says so, my lord, your lordship may kindly refer to the relevant portion, my lord, para 19, my lord. Para 19.
Yes.
The court then continued its discussion as follows. The provision of section 39 makes it clear that 3 conditions are requisite for exercise of jurisdiction to cancel an instrument. The instrument is void or voidable against the plaintiff. Plaintiff may reasonable apprehend serious injury by the instrument being left outstanding. In the circumstance of the case, the court considers it proper to grant this relief of preventive justice. On the third aspect of the question, the English and American authorities hold that where the document is void, on its face, the court would not exercise its jurisdiction, while it would if it were not as apparent. In India, it is merely a matter entirely for the discretion of the court. The question that has to be considered depends on the first and second condition as set out above. As principles, one of the potential mischief by the document remaining outstanding, it stands to reason that the executant of the document should be either the plaintiff or a person who can, in certain circumstances, bind him. It is only then it could be said that the instrument is voidable by or void against him. The second aspect of the matter emphasizes the principle, for there can be no apprehension if a mere third party asserting a hostile title creates a document. Thus, relief under section 39 would be granted only in respect of an instrument likely to affect the title of the plaintiff or not of an instrument executed by a stranger to that title. My lord, this para 15 in the said judgment is very essential, my lord. Let us take as an example of trespasser purporting to convey the property in his own right and not in the right of the owner. In such a case, mere cancellation of the document would not remove the cloud occasioned by the assertion of hostile title. As such, a document, even if cancelled, would not remove the assertion of hostile title. In that case, it would be the title that has got to be judicially adjudicated and declared, and the mere cancellation of an instrument would not achieve the object. Section 42 of the Specific Relief Act would apply to the case, such a case. The remedy under section 39 is to remove a cloud upon the title by removing the potential danger, but it does not envisage an adjudication between competing titles. that can relate only to the instrument executed or purported to executed by a party or by any person who can bind him in certain circumstances. It is only in such cases that it can be said there is a cloud on his title and an apprehension that if the instrument is left outstanding, it may be a source of danger. Such cases may arise in the following circumstances. This is very essential. A party executing the document or a principal in respect of a document executed by his agent, or a minor in respect of a document executed by his guardian, de jure or de facto. A reversionary is in respect of a document executed by the holder of an anterior limited estate, a real owner in respect of the document executed by the benamor, etc. This right has also been recognized in respect of a forged instrument which could be cancelled by a party on whose behalf it is purported to be executed. In all these cases, there is no question of document by a stranger. The title is the name, but if of a person asserting Aus title, the source of claim of title is different. It cannot be said that to be void against the plaintiff as term void or voidable implies that but for vitiating a factor, it would be binding on him. That is, he has a party to the contract. My lord, the very essential fact is, my lord, this entire judgment quotes about the action in rem, action in personam. Section 31(1) clearly implies that this is an action in personam, which the court holds that. Your lordship may kindly refer to para 21, last sentence, my lord. Para 21 and 27. The principle behind the section is to protect a party or a person having a derivative title to protect from such party from a prospective misuse of an instrument against him. A reading of section 31(1) then shows that when a written instrument is adjudged void or voidable, the court may then order it to be delivered up to the plaintiff and cancelled in exactly the same way as for rescission of a contract under section 29. Thus, it is clear that the action under section 31(1) strictly an action inter parties or by persons who obtain derivative title from the parties, and thus in personam. Your lordship may kindly concluding part of the judgment is at para 27, my lord. The court concludes by stating, my lord.
Yes.
Judged by these authorities, it is clear that the proceedings under section 31 is with reference to specific persons and not with reference to all who may be concerned with the property underlying the instrument or all the world. Clearly, cancellation of instrument under section 31 is as between the parties to the action and their privies and not against all persons generally, as an instrument that is cancelled is to be delivered to the plaintiff in the cancellation suit. The judgment delivered under the section 31 does not bind all persons claiming an interest in the property inconsistent with the judgment, even though pronounced in their absence. My lord, in this case, my lord, section 31 is clear, my lord. They have made them as a parties to the present suit, my lord. And they advert to in the pleadings that there is an existence of a document. In view of the fact that, my lord, the action under section 31 is judgment action in personam. Therefore, my lord, having made me as a party, my lord, the concerned parties as a parties, my lord, it was a duty cast upon the respondent to make them to plead and specifically assert for cancellation of the deed, my lord.
You are defendant number 18, Allah.
Allah, I am not defendant, my lord. I am a
Not even
subsequent purchaser, my lord. The with regard to maintainability of suit and the application of section
Yes.
31. My lord. With this aspect of the matter, I plead your lordship may kindly allow the appeal.
Yes, sir.
Now kindly see the synopsis which just now I have given. I'll not repeat anything, my lord. Whichever is relevant, not by way of reply to reply, only to clear the facts. Written synopsis.
Yes.
There are three synopses, my lord. One is combined return argument. Second one is appeal wise. Third one is the application which are pending chart wise. Now, as per this, okay, in page number 1, the relevant facts which are not narrated are repeated, my lord. Now kindly see, suit for declaration, no dispute. What are the prayers? What is the pleadings? Insofar as the acquisition of property by Subra Shetty not in dispute, exhibit P1. P2 is the date of death. P3 is the P3 to 8 RTC and all. Now kindly see serial number 6. Now one this is with regard to cause of action. Serial number 6.
ಎಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Synopsis first page.
ಯಾವ ಸಿನಾಪ್ಸಿಸ್?
Written arguments and synopsis. Yes. Now much was argued that as per exhibit P10, that he was a minor, he had no capacity to purchase one of the property as per that exhibit, that is the sale deed, purchasing of a house. Now kindly see exhibit P10, which says the earning capacity of both Subrai Shetty as well as Hanmantrai Shetty. They have purchased the shares. Exhibit P10 and 11 are the share certificates.
ಎಸ್,
P10 and 11.
ಅದು ನಿಮ್ಮ ರಿಟರ್ನ್ ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ರೆಫರೆನ್ಸ್ ಇದೆ ಅದು?
Serial number 7 and 8.
7 and 8, correct.
Yes. So it was argued that they had no financial capacity to buy one of the house, and inference is that 1,400 to it was made to 2,000. Therefore, they have purchased the property. From this document, my lord, that submission is negative. This is not on record, my lord. I am furnishing for the reference. Hanmantrai Shetty was appointed. Sorry. Kindly come to page number 2. This was not produced, my lord, because they have made a reference. Kindly come to this is the letter issued by the State Bank of Mysore, that he was working as an employee and on the endorsement. Kindly come to next page, first line. Date of appointment.
57.
Yes, that sale deed as of the year 1959, which they were referring. And that property was purchased, and schedule says that it is situated at Malo. Now kindly see serial number 9, exhibit P40. The photographs which were produced along with the evidence before the trial court shows the nature and vacancy of the property.
According
Yes.
to vacant land.
Yes, Mila. Therefore, to say that from 1989 only there were so many construction is not correct. Now kindly come to serial number 15.
Yes.
With regard to their negligence and carelessness, my lord, from 35 years from 1989 till date, that too in the year 2022, when the matter was ready for final argument, they have filed application. In support of that, I have only referred that judgment, important paragraph 2023 SCC online, SC 358. I will give that judgment, my lord. I'll read out the exact the observation. In such circumstances, we have absolutely no hesitation to hold that the original defendants failed to raise sufficient appropriate pleadings in the written statement that they have better right for possession of the suit properties. No amount of proof offered without appropriate pleading would have no relevance. Therefore, everything was argued, whatever has happened prior to 1989 without pleadings and all. If the pleadings were to be there before the trial court would have framed proper issues also. Now, according to my submission, my lord, 1989, 2001 suit was dismissed. They were very happy. Till the time appeal was filed and it was remanded. Even after remand, 2 years were there. Some of the defendants have filed. Not even a single sale deed of their own. Not even 1946. No reference, nothing. And the reference which was just now read out is of the year 1994, which is pendent LI transfer. Now kindly see serial number 16, submission number 16. That the main arguments is that proper issues were not framed. One thing is that there is no written statement. If the written statement are there and if the proper issues were not framed, then remedy available under Order 14. Because they have not filed written statement, they did not even choose. Therefore, Supreme Court says, if the parties understand and went for a trial, later they cannot turn around and say that proper issues were not framed. I will not read out, I made the marking of the judgment. Now kindly come to 17. Who are the defendant claiming which property? For the easy reference, I have made a 17. Now this is very important, ma'am. The suit schedule properties are totally measuring 52 acres, 22 guntas and decrease past in respect of entire properties. However, out of 19 defendants, only defendant number 5, 6, 7, 9, 11 and 13 have filed this appeal. Remaining all the defendants have accepted this decree and they have not come before the this honorable court. Therefore, the extent which they are claiming now, only the appeals which are filed, is only around 8 acres. Now to say that the parties who are not before the court and to set aside the entire decree, which is unsustainable. It is as good as partially setting aside decree and in respect of the person who have not even before this honorable court. Now, in so far as points for consideration, this is already covered by my learned senior.
Now, what about those batch of appeals?
Batch of appeals also.
That covers the entire 52 or it only relates to 8 acres?
That is what I have gone through and I made a chart also. Entire appeals were read out and only sites are there. Even that is considered, it will not come to 15 to 20% of the total extent. If 30-40 sites andru kuda.
50, 80 LI.
Alla, ade.
100 by 80 LI.
We will complete.
Nam complete.
Extent matter.
Idunna, we have taken a lot of effort, who have filed, under whom they are claiming, what is the extent, and 90% of the transaction which they have now filed are all GPA transfers. And in one of the chart which I have made, one person's Lakshmaya execute GPA in 1992. He dies in 1993. But thereafter, on the basis of GPA, more than 100 transactions have taken place, which is it by Suraj Labs.
Whether it's coupled with interest or it is just a plain.
Normal GPA affidavit agreement by their own pleadings. I have narrated everything in the chart. We have gone through the entire appeal grounds. They only say GPA affidavit agreement. Suraj Lam case straightly applicable. And that too after the death. The person, the GPA dies with the person, still the so many transactions have taken. Which they have not argued for the, because I have submitted before the sample court that we'll make a chart for easier. Individually we have made, and out of these chart, only these defendants who are before the court are only the persons.
Yes.
Now, page number 3, 4 and 5, my lord, which is already covered by my learned senior counsel. 2020. You put it.
For left out transposition, inordinate dealing, and dispendency.
Yes. On 3 propositions regarding dispendency, lispendency, transposition which he has not argued, but I will assist this honorable court because there were 2 other appeals which were withdrawn, and in the meantime a transposition application is filed in the connected matters.
That application is decided or?
No, not yet decided. That is what we have objected for.
Or the transposition application is filed in which appeal?
343 of 2020.
CPC. There is a judgment which covers the issue. Whenever there is a collusion or abandonment of right under 23 rule 2, then only you can come as a transposition, come as a pro forma party.
What are the details of those appeals which were withdrawn?
Which were withdrawn.
RFA 505 of 2023.
Why not?
5 of 2023.
23
RFA 14 of 24 of 2023.
and also 24 of?
In those appeals, there was
Appeals are withdrawn.
yes. In those appeals, there was inordinate delay. We have submitted the detailed objection with proof that they were aware of the proceedings long back. Therefore, appeals were withdrawn. And immediately the applications are filed simultaneously.
They present to
Transposition.
Which is that RFA? Transposition application is filed in RFA?
343 of 2020.
343.
The transposition applications were filed prior to withdrawal.
Huh?
Transposition applications were filed prior to
Oh,
withdrawal.
prior to withdrawal, huh?
Simultaneously. After filing the objection to condonation of delay, my lord, the applications were filed, their later appeals were withdrawn.
Yeah.
Transposition, my lord, which I have just now given, when can be entertained? Two conditions to be satisfied. One is,
Anyway, I'm quite open. I'm not going to decide that transposition.
yes,
I'll decide the main matter,
Yes,
then I'll
sir.
say that it is not relevant.
because yes,
I'll withdraw the.
only to show the conduct only, my lord, not it is going to affect the appeal. If they are ready to withdraw.
Sorry, I forgot your name. Mahesh ಅಲ್ಲ ನೀವು?
Yes.
ಮಹೇಶ್ ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಏನ್ರಿ?
No,
ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಹೇಳ್ರಿ. ಬೆಂಗಳೂರಲ್ಲಿ
there are,
ಬೆಂಗಳೂರಲ್ಲಿ 35 ವರ್ಷ ಆದ್ಮೇಲೆ ಒಂದು ದಾವ ಹಾಕ್ತೀರಾ, 35-40 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿ ಡಿಗ್ರಿ ತಗೊಂಡು then you have meddled, you have enriched yourself, partially you have succeeded also,
yes,
and I have to deal with those. So see, look at the conduct,
yes, my lord.
and the lawyer who has drafted, a very cleverly drafted, sir.
Yes.
And look, the court, you need one independent court to deal with all this now.
Yes, my lord.
Just, just imagine,
As an impartial
Mahesh,
submission.
Mahesh, if this court is compelled to remit back, just imagine what is going to happen there. Just imagine,
Again,
you need one designate court to deal
Deal
with
with
this
this.
one list for another 20 years.
yes,
So we'll go by first principles, we'll only examine
the validity of.
whether your
Maintain-
suit in absence of zero defense,
Yes, maintain.
maintainable, whether you are entitled for reliefs that were sought in the plaintiff.
Yes,
Asta will keep it as simple as that.
yes. Ma'am. As an impartial from out of the.
Don't look
this
at their
matter,
conduct. Your conduct,
because-
if I were to really examine your conduct, and I'm going to
Even
refer to
after-
some of,
Even after remand, my lord,
41 rules.
let
for-
Mahesh complete, let Mahesh complete.
even after remand, my lord, 2013 also, two of them have filed return statement, and if one of the deed
Ah,
is come to the light, my lord, either by way of amendment or I would have succeeded or I would have not
Mahesh,
succeeded. My lord.
Mahesh, you should be thankful to all the dependents.
Vice versa is also because
They have
the,
helped you, and you have earned sufficiently.
yes,
You have earned sufficiently. Huh? Based on a decree of medal, they have created third party rights. There are further complications. And these litigations will go for ages now.
without even proper
Overlapping,
adjudication.
overlapping, there is a sale deed by you. Now we don't know, subject to the judgment that will be rendered by this court, there will be further complications. I thought ಎಲ್ಲ appeal ಅಲ್ಲಿ
Insofar as the written submission, individual appeal wise, I have given the citation to
Right.
cover lispendency, transposition of parties and
ಅವೆಲ್ಲ
inordinate
dispendency.
delay.
subject to result.
Yes, yes, ma'am. I have already marked it. I will
Either they
not
will
read it.
succeed,
Yes,
either they will succeed along with dependents,
yes, ma'am.
or their appeals will go.
And insofar as this 30 was section 31, which is now read out, this judgment is of the year 2021. The judgment which I have relied upon, which is the latest 2024, and very specifically stated, the word may used in this section, therefore, even in the absence of seeking any cancellation. More particularly, section 31 says cancellation of instrument based on 3 grounds, ma'am.
No, no, you have-
23 of the,
no, you can't be called upon to seek cancellation,
yes, my lord,
but you have to seek a declaration. You have to
not
cite,
bind.
you have to cite the transactions and
Yes.
you have to say that these transactions do not bind on me for these reasons.
Yes, ma'am. That was not in the, yes, ma'am.
The point.
Therefore, even main section,
Because you are not party.
yes, we are not
Not party.
parties.
You need not
Therefore,
seek cancellation.
yes, ma'am. As rightly said by your lordship, the division bench judgment also which I have read out.
Correct.
Yes,
My lord, moreover, the judgment which I have cited is a constitutional bench judgment, my lord.
ನೋಡಿದೆ ನಾನು ನೋಡಿದ್ದೀನಿ. I have read the judgment already.
Please.
Mahesh,
yes.
Mahesh, I am going to allow all those delay applications. Your objections are there, no?
Delay application,
ಇದು ಇಲ್ಲಿ ಬರ್ಕೋಬೇಕು ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ದಿ ಕೌನ್ಸಿಲ್ಸ್ ಆನ್ ರೆಕಾರ್ಡ್
in that judgment which I have relied upon, if
Ah.
one of the appeal delay is condoned, the other party with the same challenging the very same judgment cannot claim the delay if it is beyond it. A judgment
ನಮ್ ಕೋರ್ಟ್ ಅಂತೂ ಡಿಲೇ ನಾವು ನೋಡಲ್ಲ, ಮೆರಿಟ್ ಇದ್ರೆ ನಾವು
30.
ನೋಡೋದೇ ಇಲ್ಲ.
12 years ago.
ನಾವು ನೋಡೋದೇ ಇಲ್ಲ, ಪ್ರಶ್ನೆ ಇಲ್ಲ.
Leave it to
And that is more, see, these appeals are offshoot. They
Yes.
are hinging, they rather hinge on
rights.
just one branch on which they are complete. These appeals are offshoot. They depend on what we decide in these appeals. ಬರ್ಕೊಡ್ರಿ. In RFA, 14 of 2023, there is inordinate delay of 9 years, close to 9 years. The plaintiffs have filed detailed objections to the delay application. And there is a serious contest. And there is serious contest to this application filed under Section 5 of Limitation Act. So, delay in Article 14 of 23 is found to be inordinate. This court needs to examine. This court is compelled to take cognizance of the orders passed in connected appeals where a delay of close to 8 years was condoned in RFA 342 of 2022. Next part, this court has to consciously bear in mind that the appeal under Section 96 is a statutory appeal. This court under Section 96, being a fact-finding authority, final fact-finding authority, has to decide the property rights of the party to the appeal when substantial rights are involved in immovable properties. Time and again, Honorable Apex Court and this court have held that, have consistently held that liberal approach needs to be exercised in such cases, while main thrust should be on adjudication of the rights of the parties on merits rather than adopting hyper-technical approach. Having regard to the fact that this court has adopted a very lenient approach and inordinate delays condoned in connected appeals, this court is of the view that appellant in RFA 14 of 23 on parity is entitled for benefit and protection at the hands of this court to enable him to prosecute his appeal on merits. In the interest of justice, this court is of the view that this is a fit case to condone inordinate delay of so and so years, subject to appellant, ಯಾರ್ರಿ 14 ಅಲ್ಲಿ ಯಾರು apparable,
Pradeep.
subject to appellant depositing a cost of 2,500 payable to advocates class fund. ಅದ್ರಲ್ಲೂ ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕೆಲ್ಲ ಲೀವ್ ಕೊಟ್ರೆ ಪ್ರದೀಪ್ ಹೌದು. Tell me, I'll not impose a cost of 2,500. You tell me. No, you tell me. ಹೋಗ್ಲ್ರಿ ಕ್ಲರ್ಕ್ ಫ್ರೆಂಡ್ ಹೋಗ್ಲ್ರಿ ಒಂದ್ ಸ್ವಲ್ಪ. Only lawyers will not make fortune.
For a very nominal amount, those appeals are filed.
I know they are all individual purchases. ಅಷ್ಟು ಕೊಡ್ಲೇಬೇಕು. They have to be put to terms to grant leave. ಎಷ್ಟು ಪ್ರತಿ ಅಪೀಲ್ ಅಲ್ಲಿ ಎಷ್ಟು ಆಮೇಲೆ
Few of them are very poor people.
ಆ
Few of them are very poor people.
ಪೋರ್ ಬೆಂಗಳೂರಲ್ಲಿ ಪೋರ್ ಏನು ಈಗಿನ ಕಾಲದಲ್ಲಿ 500,000 ಏನ್ ಪೋರ್ ರೀ 1,00,000 ಮೇಲೆ ಅಂದ್ರೆ ಪೋರು BPL ನೋಡಲ್ಲ. ಎಲ್ಲ ಲೀವ್ ಅಂಡ್ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಎರಡು ಸೇರಿ 1,000.
500.
ಅಲ್ಲ 500 ಲೀವ್ ಅಂಡ್ ಡಿಲೇ ಎರಡು ಸೇರಿ 500 ಕಮ್ಮಿ ಆಗತ್ತೆ. ಎಷ್ಟು ಅವರು 1,000 ಅಂತ
No. Combined both of the applications, 500 would be proper.
500 ಕೊಡಿ ಬ್ಯಾಚ್ ಅಲ್ಲಿ
In 8.51 in the 20 appeals, Srinivas Rao is not even appearing. Non-compliance of office objection alle ide.
ಕರೆಕ್ಟ್ ಮಹೇಶ್.
Alla, we don't,
It all depends.
no. That is what. That is what. If he is also not appearing in which appeal,
ನೀವು ಇಟ್ಸ್ ಯೋರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ. ಯಾರವರು?
ನಾನು ಹೇಳ್ತೀನಿ.
You know him?
I know.
Why is not appearing?
at least he should appear and make submission to that effect. It is all.
They have engaged Pradeep Mahesh.
ಅದ್ ಅಷ್ಟೇ ಹೇಳ್ಬಿಟ್ರೆ ಸಾಕು. 851 ಇಂದ 860
ಅವ್ರು ಬಂದಲ್ವಾ ಮಹೇಶ್?
ಬಂದೇ ಇಲ್ಲ. We thought that he is
No, you
also
take the
Srinivas.
responsibility.
We'll put a word.
Put a word ಅಲ್ಲ.
He is
And
also
I can't
Srinivas.
decide those all appeals. Why is not appearing? What's his name?
Srinivas Rao CH.
I thought he is also Srinivas. He is only that, but after asking, he
You
said
know
he
him?
is different.
He has spoken to me. I'll just.
What's wrong with him? We'll refer his name to bar council. ಏನ್ರಿ ಅಪೀಲ್ ಎಲ್ಲ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಬರಲ್ಲ ಕೋರ್ಟಿಗೆ. You ask him to come at 2:30. ಆ ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಒಂದು ಫಾರ್ಮಲ್ ಆರ್ಡರ್ ಮಾಡುತ್ತೆ.
ಆಯ್ತು.
ಇದ್ರಲ್ಲಿ ಕಂಟ್ರೋಲ್ ಅಂತ ಪಾಸ್ವರ್ಡ್.
Just one submission. Virat.
ಹಾ
In all of this appeal, 52 acres, there is no record available to correspond each of their extents. So all the plaintiffs defendants have a common ground. 41 rule 4, each of the defendant.
will not see. Mahesh has got a very important point. He has to be appreciated the manner in which he has prepared his response to your appeal. A very valid ground, but I will answer that also.
Yes.
Subject matter is whether this plaint is maintainable in the present form. So extent may not be of consequence, but I have to answer his question.
Yes.
I'll answer.
Assisted.
Pass over and come
Yes.
back. ಇದು ಇದೆಲ್ಲ ರಿಸರ್ವ್, ಮೇನ್ ಮ್ಯಾಟ್ರಸ್ ಎಲ್ಲ ರಿಸರ್ವ್. ಈ ಬ್ಯಾಚ್ ಗಳ ಮಧ್ಯಾಹ್ನ
2:30.
ಅದೆಲ್ಲ ಕಂಪ್ಲೀಟ್ ಬ್ಯಾಚಿನ ಮಧ್ಯಾಹ್ನ. ವಿಲ್ ಕನ್ಸಿಡರ್, ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಲೀವ್ ಅಂಡ್ ಡಿಲೇ.
No, sir, on the 17 of the appeals are not here, madam.
Is list ಕೊಡ್ತಾ ಇದೆ. List
Not connected.
List we have maybe. After that he has filed while arguing the matter. ಆಯ್ತು ಲಿಸ್ಟ್ ತಮ್ಮ ರೆಫರೆನ್ಸ್ ಇದೆ. ಅಷ್ಟೇ. ಆಯ್ತು.
ಅದ್ರಲ್ಲಿ ನಿಮಗೆ ನೋಟಿಸ್ ಹೋಗಿ ಅಲ್ವಾ ತಗೊಂಡೆ?
ಅದು ಪುಟಪ್ಪೇ ಆಗಿಲ್ಲ.
ಪುಟಪ್ ಆಗಿ
I'll take notice.
ತಗೋ.
Yes.
ಇದಷ್ಟು ಮಾಡಿ ಬೇಕಾದ್ರೆ ಅದನ್ನ ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ಳೋಣ. ಅದನ್ನೆಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಹಾಕೊಳ್ಳೋಣ.
It was not connected to this batch matters.
They are not
They
connected.
were not connected.
ಇದನ್ನ ಮಂಡೆ ಹಾಕಿ
ಇನ್ಯಾವ್ದಾದ್ರು
ಮಂಡೆ ನಮ್ಮ
ಹಾ? ಅಷ್ಟೇ ಇರ್ಲಿಲ್ಲ. ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದು ಅಷ್ಟೇ, ಆದ್ಮೇಲೆ add ಮಾಡಿ.
ಕೊಡಿ ಬರ್ಕೊಡಿ.
Those matters will be listed on Monday.
Please.
Yes. Lordship may direct me to accept notice for response.
ಅದಲ್ಲಿ ಮಂಡೆ
Common, yes. Two 30.
Yes, sir, 2:30, Pradeep.
A previous council is asking me to, he has filed retirement memo, still his name is, he has asked me to delete. First ಅಲ್ಲಿ ಬಂದಿದೆ, ಅವ್ರು
ಆಯ್ತು.
ಕೇಳಿದ್ರು.
ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾ ನೋಡಿ.
ಆಯ್ತು.
ಎಸ್ ಎಸ್ ಸರ್.
Yes.
ಅದಿದು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಆಮೇಲೆ ನಿತೀಶ್ ಇದಾರ ಅಲ್ಲಿ ಬಂದಿದಾರ. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಆಮೇಲೆ ಇವ್ರದ್ದು ಆದೇಶ ಇದೆ ಸೀಲ್ ನಂಬರ್. That is substantially hard. ನಿಮ್ದು your read to comments or what? ಇದ್ರಲ್ಲಿ
ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ರಿ, ನೀವು ಕೇಳ್ಬಿಟ್ಟು ಸುರಾನ ಅವ್ರೇನೋ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಕರೆಕ್ಟ್.
ಆ ಕೇಸಸ್
ಆಗಲ್ಲ ಬಿಡಿದು.
ಅಂಡ್ ಈವನ್
Got too many partner matters in. ಆಗಲ್ಲ.
ಶಾರ್ಟ್ ಇಶ್ಯೂ ಮಾಡಿ ಅವರು ರೆಡಿ.
ಶಾರ್ಟ್ ಇಶ್ಯೂ ಏನಿಲ್ಲ ಬಟ್
Some of it. List it immediately after vacation.
My lord, so far as 23A, I have handsome, my lord, I file it in the.
File it in the office.
In the meantime,
So far 24, my lord, 20, respondent 24, even he has expired and I have filed an application to bring the legal aids on record.
Whether they listed today,
It's listed today.
you have to take notice.
I mean, at the order illa under handsome.
No, I think you want to take hand summons there also. No, you have to take both, court notice and hand summons. ಎರಡು ತಗೊಳ್ಳಿ.
ತಗೊಂಡಿದ್ದೀನಿ, ಇನ್ನ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
ಇನ್ನೂ ಆಗಿಲ್ಲ. ಅವೇಟ್ ಅಂತ ಹೇಳೋಣ ಬಿಡಿ. ಆಲ್ರೈಟ್. ಒಂದ್ ಡೇಟ್ ಕೊಟ್ಬಿಡೋಣ, ದಿಸ್ ನೋಡೋಣ. ಲಿಸ್ಟ್ ಇಟ್ ಒಂದ್ ಡೇಟ್ ಕೊಟ್ಟು ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಯಾಕಂದ್ರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅವರು ಹ್ಯಾಂಡ್ಸಮ್ ತಗೊಂಡು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಎಸ್ ನೋಡೋಣ, ಡೇಟ್ ಕೊಡ್ರಿ ಒಂದು. ಎಸ್ ಸರ್. ಹಾ till number 10.
for the respondents, my lord,
ಕಲ್ಯಾಣ್
Right,
ಬಸವರಾಜ್
my lord, I request
Retire
for a
ಆಗಿ-
passover.
Passover.
He's in the other court hall, my lord. He's addressing the arguments. I request for a passover.
All right. ಏನಾಯ್ತಾ ಸೆಟಲ್ ಆಯ್ತು?
ಸೆಟ್ಲ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಕೇಳಿದೆ ನಾನು. ಇಲ್ಲ ಇದ್ರಿ
He's in another court hall. He's in the next court hall.
Okay, we'll pass over, we'll see it at 2:30, sir.
ಅದು ನಂಗೆ 2:30 ಆಯ್ತು ನೋಡೋಣ. ಐ ವಿಲ್ ಟ್ರೈ ಟು
Yes.
7 ಅವ್ರಲ್ಲ ಶುರು ಮಾಡ್ಲಿ, ನಾನು ಅಕಸ್ಮಾತ್ ಹ್ಯಾವ್ ಅದರ್ 2
Okay, ಅದ್ ನೋಡೋಣ ಸರ್, ಇವತ್ತು ಆಗತ್ತಿಲ್ಲ ನೋಡೋಣ. Some parted matter.
ಇದು ಪಾರ್ಟ್ ಮಾಡಿದ್ವಿ.
ಇದು parted ಇದೆಯಲ್ಲ?
ತಾವು ಕೇಳಿದ್ದೀರಿ.
We'll hear it. I've substantially heard it.
ಆಯ್ತು.
All right, pass over.
Judgment.
11. Yes, sir.
The synopsis of the case is in brief. The food for specific.
Wait a minute, I prepared notes. Let me go through the notes.
I just wanted to read one.
Synopsis on file ಆಗಿದೆ.
ಆಗಿದೆ ನಾವೆಲ್ಲ ಮಾಡಿದ್ವಿ.
3823.
ನೀವು ಇರ್ಲಿಲ್ಲ ಅವ್ರು ಹಿಂದಿನ ಕೊಟ್ಟಿರೋದು ನಿಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ. ಕೊಡ್ತೀನಿ ಮಧ್ಯಾಹ್ನ ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ.
I think you stopped where you made a submission that dependents 4 and 5 have put up a construction. They made a statement that it is not by them.
So far as, as I know, it's a temporary construction, not a permanent construction. And there is a construction subsequent to the filing of the suit, according to me. And in fact, an application was filed for an order of injunction restraining them from putting up a construction. This court has also granted it. Now, your lordship may kindly see, the learned judge's findings are, the trial court finding is that I have not proved the ready and willingness, that I didn't have the balance of self-consideration. The fourth and fifth defendants are the bona fide purchasers, pendant light purchasers are held to be bona fide purchasers.
There is a finding that they are bona fide purchasers.
Yes, bona fide purchaser. And the defendant's claim is.
Agreement is proved,
Agreement, everything is admitted.
their readiness and willingness, and they are held to be bona fide purchasers.
That's all. The defense of the defendants were the vendors are that I did not have a funds. So I asked them to return the amount. They returned the amount, the agreement, the original agreement was handed over to them. The defense of the original vendor, that's the 1 to 3, is that I did not have enough funds, so I requested, please give me back my money, I will cancel the agreement. Accordingly, they came to the defendant's first defendant's brother came to my office. He is calculated that the 2,05,000 is the amount you have paid, 50,000 is the interest, 2,55,000 he paid it to me and took back the original agreement. That agreement, they produce it along with the written statement saying this is the agreement that was entered into. The court, after hearing while dictating the judgment, sent the records to the FSL to find out whether the document produced by the defendants 1 to 3, which according to them is the original agreement, is an agreement.
You have the cancellation.
Cancellation agreement.
That is held against them.
That was held against them and in prosecution was instituted against them under 340. Now, the learned judge also entertains some confusion which I am unable to comprehend. He says, the agreement, you are an advocate, the agreement is one-sided. You have no right to institute the suit at all. I don't know where he gets it. Anyway, that's the finding. On that ground also, your lordship may kindly see the para 14 of the judgment. In the 14, the judgment of the at page 272. At page 272 of the paper book and page 25 of the internal page of the judgment. I mean, I am unable to comprehend how did he arrive at this conclusion. Para 14, your lordship got it?
Yes.
Apart from that, on perusal of exhibit P1, the default clause, which shows the defendant has to approach the court for specific performance of a contract in failure of the terms of the agreement by the plaintiff. In my considered opinion, the default clause made by the plaintiff himself being an advocate, the terms of the agreement was one-sided and it is in his favor, that cannot be acceptable.
Whether that was complained by the defendants?
No, no plea. No plea. It's not even argued before the court. Even if it is taken into consideration, as per the default clause, the plaintiff cannot approach the court for a specific performance, specific relief. Therefore, the plaintiff is not entitled for the relief or specific performance of a contract. However, the defendant has failed to prove the termination of the contract and also failed to prove the refund of the advance amount, and therefore the plaintiff is entitled for refund of the earnest money from defendants 1 to 3 along with interest hence. So he says, I have no right to institute a suit at all.
Yes.
I mean, I don't know what is the confusion that prevailed upon the learned judge's mind. I am unable to understand. If there is a breach, if the parties are have no right to approach the court, where else they can get it decided?
Where he says that I cannot approach the court.
This is what your lordship may kindly see.
ನೋಡಿದೆ.
After about 6 lines,
Yes,
even if it is taken into
Yes, sir.
consideration, as per the default clause, the plaintiff cannot approach the court for specific relief. Therefore, the plaintiff is not entitled for the relief or specific performance. He holds clearly that I cannot come to the court. It's on that ground I am also not entitled to the relief or specific performance.
Yes.
So I think this particular observation of the learned judge is patently erroneous. It doesn't call for a wider discussion about this subject. Because in case of a breach, a party has to go to the court, has to approach the court. He says you have no right to come to the court is patently erroneous, which cannot be accepted.
Yes.
Now, the second aspect, the learned judge feels it, the plea of the defendant that they admit all amounts except the amount received on 29,595. Your lordship may turn to the agreement, exhibit P1 at page 96. Endorsements are made. Page 96, your lordship may kindly see.
ಅದೇ 25,900. 25,900.
25,900.
1,50,000.
This particular amount has not been paid. That's the defense of the defendants. And that is accepted by the court. This amount, he says, is interpolated. The learned says it's interpolated. So you have not proved the payment of and that doesn't contain the endorsement. That doesn't contain the endorsement. Your lordship may kindly see. Exhibit B to your lordship may kindly see.
D1.
ಏನಿದು page 200?
Endorsement made on the agreement. Original agreement, good agreement. Good agreement, I brought it to the court, notice in the court that even the endorsement is there. He said, I had obtained the xerox copy of it. That shows that endorsement is just so it is interpreted by the applicant. By cross-examination of last pertaining this, I said, I have suggested the things that you have taken this xerox and removing these entries.
Yes. What's his answer?
At page 57, the last pertaining this, at page 57, cross-examination that you can one.
He's examined as DW1,
Yes, BW1.
page.
Page relevant thing is a very starts at
Yes.
May I read that to the forthcoming non-motion,
Yes. Yes, sir.
Now, I have seen the previous show to me, appearing at on video, they are not. Signatures of myself and my right concern. One in Malaysia and Ashok Naidu have signed agreement as even as attesting witnesses. The legal agreement is attested by two witnesses. One is Malaysia and Ashok Naidu. It is true that the signature of the witness of even are not contained in the Xerox copy. The signature of the witness are not there. It is not to suggest that I got the Xerox of the agreement and we were excluding the signature of the witness. It is not to suggest that I also got the Xerox approval.
All right, you can bank on only that admission where he says his signatures of witnesses are also missing. So that is relevant.
Part of this, according to them, according to me, on 29/5/95, I paid 1,50,000.
Yes.
According to the This enlargement of 495 let us prove the difference. For a moment, I accepted. And their big is they return amount to me on 21/5/1995, the whole the market. Over this prior to the enlargement. They just made this and I went to that 55,000. Took back the one. Let us see the notice. Before I just put that in issue that we issue a note. That note is present. In that note, I have taken the. Also paid. So the standard with the party is prior to 6 months to transaction is paid amount and this should be not a response. Basic, in any man who feels who according to the balance to cancel having paid amount. Who is not said, no, you are looking this to the past, you have paid that. Now, what is the answer? So, for us to that.
Already you referred to your legal notice marked as exhibit.
It is the notice. Article 99. The third notice was held under the certificate of posting by courier and by register. Certificate of posting is that it will be more.
Yes.
Three filing the acknowledgement by the department as far as held by courier. The register posting register. The future return back. When we turn to the last examination on this aspect, because I just want to lay down easily.
Courier is accepted
He says that he admits there is single notice.
through courier.
He admits.
Yes.
He admits it.
Alright, exhibit P5 is courier.
When we turn to the cross examination of the first defendant,
Page,
58.
yes. Yes,
I have not received any notice from the plaintiff. The witness states that they received the notice sent by the plaintiff to his advocate. I have not given any reply to send the notice. Apart from who this acknowledgements, I the plaintiff, the defendant also admits. And his conduct of not repaying the notice belies his contention that he has not received 1,03,000 and that he has cancelled the agreement by going to.
yes.
Now, so far as evidence regard to 255, he says, I did not have. I did not have. So I requested my brother to take it to that 55,000 rupees. My brother went to the office of the change it. Of course, he said, okay, he put 2,05,000 is the amount that I have paid. 50,000 is the interest, 2,55,000 is the total amount. You paid it in cash in your hand. I returned it. Both of them. And the both cross examination. He admits to repeated admit that he did not accompany
He did not,
accompany his brother or cancellation. His brother alone went. And he does not have the money to pay the amount.
The transaction was with different number one. He says your brother went and got it cancelled.
Now he says my brother went there alone. The lady person and he said, okay, I don't have money to pay the balance of the same installation. So return the amount, they return the amount in the month of May 95.
Yes.
Now, to the last 2007, draft examination, it was to show that the entire objective capital of the court is not so far from
Page?
57,
Yes.
draft examination. You have to first, second line to the top. The second agreement was kept by another, who has to receive the amount from me, it was paid back to the date. There is no endorsement on the agreement returned by the plaintiff for having cancelled the said agreement. Since the plaintiff has received that amount, now I see the signature showed to be luckily legal. They are. Back to the last, if I can return to page 56 and forward. Page 55, at about 10 lines in the bottom.
Yes, from bottom, when my brother,
My brother gave Jairam a Nepal in amount submitted on my behalf. When my brother demanded the plaintiff for insurance in the receipt of the, for having received the amount, at that time the plaintiff disclosed before it, stating that he had handed over the original. I will not say. An amount of 2,000 was paid to the plaintiff. My brother had paid the said amount out of the amount received by him by sale of the site and also out of amount earned by him from business. I have not prepaid any remarks to show that my brother has paid the amount to the plaintiff. I have not prepared any remarks to show that my brother was having that amount to me. When my brother paid the amount to the plaintiff, myself, my wife, myself are not present, obviously evident. It is true that on the basis of the statement made by my brother for having paid the amount to the plaintiff, I impose before the court stating that my brother has paid amount to the plaintiff. It is not true that my brother has not at all paid the amount, any amount to the plaintiff at any point of time, because of the agreement. So, he does not have a personal information that he did not have it, he asked his brother, told him that I paid brother for the agreement. He believed it. Now let us look into the DW2 witness who is brother, who is supposed to have paid the amount to me. Let us see the cross examination of the brother. Cross examination is passed at page 65.
yes.
I was not present during the transaction between the plaintiff and my vendor, I do not know personally about about the amount paid by the plaintiff to the defendant for one. I take to the plaintiff to my interpreter, defendant for one after transaction. It is true that my brother friend need to the plaintiff to inquire about the transaction. I met the plaintiff in his office in happy with that, but I do not know the date on which I met him. On inquiry with the plaintiff, he has told me that he was unable to accumulate the money for the payment of the sale consideration. Hence, he has requested to return the advance amount. I am having an improvement doing manufacturing business of it. I am not an income tax assessee. I do not hold any record to prove that I was holding 2,55,000 on 25,595. That is the rate the book of the city. There is no receipt to show that he had returned the amount of 2,55,000 to the plaintiff. I do not have any document to show that activity is an amount to be paid by me. I received the said amount to the defendant of Mama. Though the evidence has taken place somewhere in the after 10 years, 2005 is the cross-examination. He has not had the record to show that the amount is reported by his brother to him. Incorrect today, I did not pay 2,55,000 to plaintiff. It is incorrect to say that it is created by me and given to the defendant in order to cheat my brother. But the exhibit P2 was $100 given by the plaintiff. It is incorrect to say that the exhibit P2 is not the document entered into the plaintiff and the defendant of all. It is incorrect to say that the plaintiff was having sufficient money to pay the balance of plaintiff. If the government says, pick the thought, I do not accept it and reject the claim of having. Now, the last question that I is now, except the 1,50,000, all amounts paid by the man being agreed by the defendant, he goes to the further extent of saying, whenever I have the money, he gives. Even 5,000 rupees, then I have to take it. Now, according to me, 3,05,000, 3,55,000, 1,55,000, what's supposed to be the balance? I have produced the passport. Exhibit P2, 1,30,000, exhibit P2,
They have gone through, ನೋಡಿದ್ದೀನಿ ನಾನು.
exhibit P15 noted, continuation to
P2.
P2,
Page.
page 98.
Yes, sir.
Other 28, 25, okay, so that is 1,30,000, page 922. As on 31/12/1995, the last year, I had balance of 2,60,246.
Balance of?
31/12/1995,
Ah,
2,63,245. I had the balance.
2,63,000 ಎಲ್ಲಿದೆ ಅದು?
After the day, after the 2,68,372.
2,68,000.
About that. Then from that 1460 was there, 31/12/95 was there. The amount to deposit on the pool there, I can balance that straight on now. And the last community, that is the bank that the balance. Was at the town, 1,30,821. The second, pricing is 1,98,000. After my depositing so much money, 1,98,000. Then I deposit to 1,50,000 rupees. So 2,69,000. 531. Balance has been struck. So, as on 31/12/19,
Yes.
I had the amount.
From where you collect the date, 31/12. And Xerox copy of CLD display.
That they have not denied, did not have a problem. They only said they are not aware. That means so, sir. I have to lose.
A Xerox copy is marked, that copy is marked, marked as exhibit. P13. It's a residential house or site?
For 3,50,000.
$350,000.
Actually, 173.
Yes.
The property was sold by me on 10/7/1995.
Ten, 7/1995.
And the 3,50,000 is accepted at page 173. I have the house with the I have got the.
Yes.
So, I had the balance. We have all the time from May to December. The probability of the plaintiff's contribution that I had no belief does not fit into the picture, because whenever he asked me again, he wanted to perform the marriage. He wanted to perform, first he performed the marriage of the second husband. I gave, he asked me again, we are good. Then it was done to marriage. Then I said, having performed two marriages in a gap of 2 months. Probably had he asked me one after the other. I get it. It looks logical and accurate. Not only the life of the environment, but also the fact that it does not relate to this point. So, my agreement is to the extent that I had paid in that 55. And the balance I had paid the passbook. I also to the operator, I had purchased the also. The government said, 1,30,000 he needs to do 30,000 in this one district. 1,30,000 rupees only he saw it and says, because he was under the impression probably that the agreement was in agreement. Contract has to be completed. So as on the date of end of the day, you did not have, you had only 30,000. Besides, I had already negotiated, I had told it, I have potential to utilize the entire. There is nobody who would think that I have the money. If I am capable of the potential to raise the money, that is very necessary. A big, for example, a big discussion in India may not have balance, but at one stroke they can get 1 to 5 percent. The potential of money. I have a practice in that, but I have like, I mean, this money I had it. And I had a property which I had agreed to sell it because I wanted to shift the value reserve to that much in another. Get it good education because the value reserve was posted to the domain of some particular class of people who wanted to stay in London. He had a money, he had a house in English front park, just about 4 kilometers. Very uncomfortable, he wanted to come here.
Yes.
The entire conduct of the state is in admitting all the transactions except the statement. So that I was always, he in fact himself says clearly categorically in the court of the process normally, when Whenever I demanded money, it is the limited comes to the conclusion, apart from that, we don't have to. You are supposed to pay the bank duty. But the property is not yours. As we do not, we can accept the bank. The remaining amount, about 300, have to be paid to the bank. Yes, I did not pay the bank. Why I did not pay the bank? He could pay different income than this, my second or about my whom they are married. Please give.
All right, now what's your cross examination on purchaser? I was not informed.
He said, I was not informed at all. I am not one of it. That's all. Because his evidence does not have any weightage in the fact that he did not choose to make any inquiries reasonable. He then the defendant admit after issue of the note after issue of the summons from the court yesterday. And he conveniently supported the other. I did not inform the proposed what he said. The beneficiary, the whole maximum beneficiary is the person in the vendor. He collected 3,55,000, 3,55,000 from me. He collected 5,10,000 okay. He, at the time of argument, he submitted files for more seeking detachment of the help from the defendants. The court, having voted permission to return. The purchasers after the summons issue a notice to him, saying that you are valid so and so. That notice is returned. He just returned. Now, put the court say under the subject. And defendant is there. The court provided that.
ಅದೇ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ 19 ಬರಲ್ಲ 19 ಬರಲ್ಲ Section.
I don't want to read more issue to the top of the line to the last to say what is. Now the Supreme Court is out there and the court purchaser private direction is not actually. He opt on.
ಬರಲ್ಲ ಅದು there's a distinction between 19(1)(a) and section 52. No.
Now, the original vendors are not going to go to difficulties.
Now by in view of latest judgment, a pendant-led purchaser or a subsequent purchaser at the most can contest this appeal and try to substantiate that you were not ready and willing. And to that limited extent, he can argue. I will step into the shoes of vendor. ಅದು ಹಳೇದಾಯ್ತು ಹೊಸದೇನ್ ಹೇಳುತ್ತೆ ಈಗ ಇಲ್ಲ ಅದು ಹೋಯ್ತು ಈಗ No, what happens because a vendor may wash off his hands, he may not contest, so he can't take away that right. To limited extent, he may step into the shoes and he may try to substantiate that your suit has to be non-suited only on the ground of readiness and willingness. ಈಗ ಅದಷ್ಟೇ ನೋಡ್ಬೇಕೀಗ because your agreement is proved now. A reappreciation only to find out whether that 1,50,000 is paid, then finding on readiness and willingness. ಅಷ್ಟೇ ಈಗ. Yes, sir.
Does not ensure the benefit.
No.
Because he intended to cheat them. And in fact, the notice issued by them to the defendant that you have cheated us. That notice is here to the student.
Is it marked? Is it part of record? Then you said that.
Exhibit D4B.
Legal notice by defendant number 3 or 4 or both. ಅದೇ ಯಾರು 3 and 4 ಪರ್ಚೇಸಸ್ ಯಾರು?
4 and 5.
Yes. Yes, para 5. Of the notice. At page 241. Yes. In view of the tendency of waste, the container is a pregnancy and all of the we are that certain manner of reporting my planning and the make out to make the and in after is regard to the art of the property is to highlight who are quite innocent and who are not aware of any of the family restrictions. You are sitting my client, supposing the material information fact whereby everything is under section 420 of the penal code. And also your committed breach of trust for which offenses you are liable to be commitment and my client intend to start with complaint against the against litigation is has arisen. In the schedule property, I have undertaken in the same day 27/8/97, you are become I have to title to dispute yourself and keep the schedule property free from all and for being recorded and my client both we as an absolute owner and also identify my client in the matter of expenses depend on right now I was trying to support the 6,000 we are liable to people. I tried hereby notify you to their intention of in the suit area. So protest the protect the right time and also in the commission. But nothing has happened beyond that. On notice was there. Refused. Audit.
ಇಲ್ಲ ಸರ್ ಜಾರಿ ಆಗಿದೆ 14A ಅಲ್ಲ ಎಲ್ರಿಗೂ ವಾಪಸ್ ಬಂದಿಲ್ಲ.
Probably that was intended to demonstrate or strengthen his case that he is a bona fide purchaser. All right. 2:30. Eruduvare. Madly then brief reply if required. That's all. It won't have to consider. Madhyana, continue, sir. Not on Monday, after vacation. No, I'm sorry. Note, ಯಾವ್ದು ನೋಡಿ? Serial number? List 4. Monday, all Monday.
Serial number 13 man.
At least. Extend.
Serial number 13 man.
Wherever there is an interim order, please mention, it will be extended.
Your
ಎಲ್ಲ
lordship's
ಮಾಡಿದೆ.
kind permission. Serial number 13 my lord. Yesterday I was not well. My mother
ಯಾವ್ದು?
is there. Serial number 13 man.
ಎಂಟರ್ ಪ್ರಾಪರ್ಟಿ ಲ್ಯಾಂಡ್ ಸೇಲ್ ನಮಗೆ ಮಾಡಿದ್ರು, ಆಮೇಲೆ ಉಳ್ಕೊಂಡು ಅಂತ ಅವರೇ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದು serial number? ಪಾಟೆಡ?
ಕಟ್ಟಡ ಅಂತ ಹೇಳಿ ಜಸ್ಟ್ ಆಗಿಲ್ಲ.
ಪಾಟೆಡ್ ಆಗಿಲ್ಲ. ಯಾವ್ದು ತಗೊಳಲ್ಲ ಕಟ್ಟ ಆಗಲ್ಲ. After vacation.
Serial number 14, my lords.
ಯಾವ
My lords,
ಡೇಟ್ ಕೊಡ್ಬೋದು.
Serial number 14, my lords. 14, my lords.
What do you want?
Senior ಇವತ್ತು ಅವ್ರ ತಂದೆದು ಕಾರ್ಯ ಇದೆ ಸ್ವಾಮಿ, ಮಂಡೇ ಹಾಕೊಬಹುದು ಸ್ವಾಮಿ. ಅವ್ರ we have also informed the party in person. my lords.
13%.
Inform ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. Monday it will be
Monday.
taken.
Your lordships, 10 and 12. This number 3. Lordship may have it at already.
After vacation.
Absolutely.
Huh?